The Kansas Adoption and Relinquishment Act makes it a felony for any person to knowingly and intentionally receive or accept clearly excessive fees in connection with an adoption. The Kansas Supreme Court considered whether a woman violated this act by agreeing to take a $400 fee that was never delivered in the 2001 case of State v. Brown. Susan Brown ran an escort service in Wichita, Kansas. Brown learned that her former employee, Samantha Pruitt, was considering putting her newborn child up for adoption. Brown brokered a deal to sell the child to another employee named Teresa Lawrence. The basic gist of the deal was that Pruitt would give Lawrence the child in exchange for a car, a cell phone, and $800 in cash. Additionally, Brown would take half of the cash, $400, as compensation for brokering the deal. The child changed hands, but Lawrence never delivered any of the agreed-upon compensation to Pruitt or Brown. Eventually, Pruitt reported everything to the police, and the child entered protective custody. After a bench trial in Kansas State Court, Brown was convicted of knowingly and intentionally receiving or accepting clearly excessive fees in violation of the Kansas Adoption and Relinquishment Act. Brown appealed to the Kansas Supreme Court, arguing that she never actually received or accepted any such fees in violation of the act because the $400 was never delivered.